Hi, I'm Nid, your wellnesspreneur and wellnesspreneur consultant, and I'm going to be running through in this video the core terms that you need to have in all your agreements, especially if they're in writing, and also something called boilerplate terms, which are often what takes up a lot of pages in written legal agreements. It's going to be a quick run through because there's quite a lot. Hopefully it's just to give you a real basic idea of what those things are that you're going to be finding in those long written out contracts, but also just to think a little bit about some of the core terms that you want to have when you are agreeing things with other people as part of your business.
A core term is something that's fundamental to the agreement, and if it's not met, it means that there is something called a material breach, which is where often the contract may be ended and there can be a claim for money, whether that is the damage of the contract not being performed or some other kind of loss that results as a result of the contract not being fulfilled as was agreed.
So the beginning thing to note when it comes to our core terms in a contract are probably going to be who are the people who are part of the agreement. So you want to know who the legal entities are who are making the agreement with one another. And that normally involves some kind of full name, address, and maybe a tax identification or business registration number. You then want to ensure that there's clarity around what is being paid, how it's being paid, when it's being paid, and potentially if there's going to be interest on any late payments. We want to set out the term. So term is the duration of the agreement. So that is it going to be monthly and rolling until one person decides to end the contract? Is it for 12 months and therefore a fixed amount of time? And how does it end? Does it naturally end, or does someone need to give the other one notice of a certain time period, say 1 month's notice, like you might do with a lot of jobs, 4 weeks notice, in order to end the period of time of working together? And also there may be other conditions that could end it. Say a teacher not turning up for 3 weeks might be a good reason for a studio to end the contract and say that the teacher's no longer going to be working for them. So those are the conditions around the term and the duration of the contract. And then we get to the obligations. So the obligations are the responsibilities of the service that we're promising to give in return for that payment. And maybe both sides are giving a certain degree of promises to each other about what they're going to do as part of the agreement. And this is where you really want to set out who's doing what, maybe how they're going to do it, how they're going to deliver it. Are there set dates by which things are going to be done? Are there conditions on which it's going to be done? And conditions are useful if it's a way of saying this only happens in the event of X happening. So that gets you out of delivering something until the event happens. So that's the condition that makes the obligation trigger, and then you have to deliver that service. So when it comes to those obligations, it's really being as clear as you can about what it is that you're going to be providing and doing for one another. And this is where you want to ensure that you don't overpromise, and you also want to ensure that it's clear what it is that you're going to be getting from the other person in return. So finally, I just wanted to touch on some what we call boilerplate terms in contracts. Now, these are terms that you might find take up pages and pages at the back end of a contract. And this is what often turns a contract from being like 3 pages long to 14 pages long. And the reason for these terms are because often this is where there's been a lot of issues around conduct or technicalities about the relationship and how it needed to end or change, or what courts listen to it, or whether or not other people are allowed to deliver some of the services. And these terms can have quite technical meanings in different courts and in different countries. So one, say, is notice, and notice is a technicality about how we communicate with each other, what is considered a effective notice to another person about the contract. We're changing the terms of the contract so that we're going to have your intellectual property rights, is something that would need to be done formally in accordance with the way the notice clause has been written in the contract. And often notice clauses require things to be in writing in order to make the changes, and should set out some kind of statement potentially about any other aspect of things in that notice, say whether it's post, email, how many days it is that would be considered notice once the email's being sent. So notice will address those kind of technicalities. You're also going to have something around what kind of relationship it is. So although you've got an intention to create a legal contract, you're not forming a legal partnership or long-term relationship. And in that sense, you're both individuals responsible for your own individual relationship. You'll also have a clause in there about how to vary or change the contract and what needs to happen in order for those changes to be made, and if that's possible. You may have a clause around subcontracting, so allowing somebody else to deliver your part of the job or your part of what's been agreed under the agreement on behalf of you. And sometimes this isn't permitted because it's not appropriate, because we're really looking for a specific person to deliver what is being promised in the agreement. So that's where subcontracting may not be allowed. And that's quite likely if you are a person delivering, say, classes or wellness services, that your studio may not want you to have someone else come and deliver for you. And then lastly, we have something called severance. And severance is where you can take clauses of the contract and basically strike them out as though they're not part of the contract if the court were to consider that that clause should not be a part of it, but the remainder of the contract is going to stay effective. And what this does is it just ensures that when one clause falls down under the court's interpretation, the entire contract doesn't then get pulled apart as well. So this is just our way of making sure that each clause stands on its own and doesn't have an impact on the remainder of the contract. I did say lastly, but I didn't mean it. There's two extra clauses, and I've talked about them in one of my insurance videos before, which are governance and jurisdiction. So governance is going to be the law that applies to your contract. So that's going to be the state and the country in which your business is operating, or the business that you're working with is operating. If you're working across states or across countries, then you're going to need to agree whose law is going to apply. Jurisdiction is which court is going to hear the case, should it go to that place and that level. And again, that's the same thing. It's going to be in your state and country if that's where your business is and that's where your partnering collaborator is also based. Or if you're in different countries, you're going to have to agree who's going to travel to whose courts if there is a dispute. The thing to note with the governance and the jurisdiction is that it can be exclusive or non-exclusive. So non-exclusive would mean that although you might say that the law that applies is that of Victoria in Australia, it could also be that another jurisdiction applies. If you're enjoying these videos and you find them helpful, my courses will give you access to more detail and examples of the kind of terms that you might want to use.